Firearms dealers in California are reeling a little bit as there has been no guidance from DOJ on Assembly Bill 574 and the implementation here in March, forcing firearms purchasers to answer the question of whether or not they have confirmed possession of all of their firearms when purchasing a new one. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, more confusion at FFLs and in the firearms community because of inadequacies of the Department of Justice. We had a new law come into effect just a couple days ago without any guidance from DOJ. We're trying to sort it out, and to talk us through that, we have brought back on Matt Cabero. He is a partner at Michelle & Associates. He's also kind of the author of this little book we call Gun Laws, California Gun Laws. If you haven't heard of it, go ahead and check it out on the website. It's a great way to understand all of the laws that are currently active here in the state, put them in layman's terms for everybody to understand so that we're not all going through the penal code like an attorney normally would. But Matt, thanks for being on with us today. I appreciate it.
Yep, thanks for having me.
Absolutely. But guys, before we get into that today, please be sure to like, share, and subscribe to these videos. It really helps get them out as far and wide as possible. And hey, everybody who is going to be going to purchase a gun currently has to be answering this question. So we want to get this out to as many people as possible so that they understand what the addition here is. It's also a great way for you to directly contribute to Second Amendment litigation and legislative efforts here in the state. So Matt, maybe we can dive into this at the beginning. In 2023, it passed the legislature and Governor Newsom signed Assembly Bill 574. Can you go ahead and just let us know what was that bill? What was the law? Why are we talking about it in 2025? And what's led up to today with all the confusion that we've had?
Yeah, so it was a very simple, straightforward bill as far as the changes it was making to the penal code. And specifically what it does is it adds a question that dealers must ask individuals when they're purchasing a firearm as part of the DROS that the dealer submits through the system, what's called the DROS entry system, or DES. And so normally you're asked several questions, but this obviously just adds a new question. Specifically, the question is, in the past 30 days, have you checked and confirmed possession of all your firearms? And so that's really it in a nutshell what it's doing. And so individuals, as we've now seen with the implementation of it, they have to answer yes or no to that question. And then also in the case of individuals that don't currently own or possess firearms, they have a third option, which they can basically select not applicable, because obviously if they don't have guns, they can't check and confirm their possession.
And actually, yeah, maybe now is a good time. Jacob, if you could pull this up on the screen for me. This is the Legislative Digest, you guys. While this bill was signed in 2023, you can see here it took effect March 1st, 2025. It reads like this. This bill would, beginning on March 1st, 2025, additionally require the register or recorder to include the acknowledgement by the purchaser or transferee that they have within the past 30 days confirmed possession of every firearm that they own or possess. So, sorry, Matt, I just wanted to get that out there so that they could see it. So that is exactly what you're talking about. It was signed in 23. It's coming into effect now. But now we have all sorts of confusion with FFLs dealing with this question. Can you dive into that a little bit? What's going on?
Yeah, so it wasn't too long ago that the California Department of Justice put out its annual summary of the changes to California firearm laws. And conspicuously absent from that summary that the DOJ puts out was this bill, because this bill was taking effect at the time that notice went out to dealers. It was going to take effect in a couple weeks at that point. And so it was interesting to see that the DOJ didn't actually put any information out on this prior to its implementation, number one. And number two, obviously we were all expecting it to take effect on March 1st, but we weren't even sure if DOJ was aware that they were going to be required to make this change. Well, now March 1st has come and gone, and we did see the DOJ do a small update to the DES system prior to the implementation of this bill. And so presumably that's what they were doing with that update. And so now on March 1st, when dealers logged into their system and they went to go run a DROS for somebody, sure enough, this question was there. But again, there's still no specific guidance from the California Department of Justice on this. I think the assumption from the DOJ probably is it's a pretty straightforward question. But obviously, there's lots of questions on what happens, how you answer that. And so, for example, if you answer no to that question, that you have not checked or confirmed possession of your firearms that you currently own, interestingly enough, there's nothing in the law that says that you can't still go forward with your transaction. And so we've seen a number of dealers that actually have processed gross transactions for individuals that answered no to this question. Now, granted, those transactions, from my understanding, are still pending. So we're not yet certain if DOJ is, for example, going to deny someone because they answered no to the question. We also necessarily haven't seen anyone specifically run a DROS yet with the not applicable option for individuals, for example, that don't currently own or possess firearms. But what if someone mistakenly puts not applicable or answers not applicable and they actually do own a firearm? It's like, what's DOJ going to do there? Are they going to deny the individual's transaction because they made a mistake in answering the dealer on that? And so there's lots of these questions that just simply aren't answered, and DOJ hasn't provided any information whatsoever. And so we're kind of in this sort of wait and see stage on some of these individuals that have answered the question this way to see what actually happens once their 10-day wait period has ended, and whether or not the system will actually allow them to proceed with the transaction that they submitted.
Yeah, and I guess just a couple points of clarification. This sort of thing could have been avoided. I guess for lack of a better term, updating, there's a couple different ways you can use the word update. You use the term update. I think what you were talking about was the Department of Justice updated the software in their system to the point where, just like when your phone tells you need to restart it to do an update. But there are other ways that the word update can be used. And earlier in February, the Department of Justice put an info bulletin into the DES for FFLs talking about all of the new laws. That's what you also mentioned. And this one being absent, providing no guidance. You and I were talking about this on another video that was specifically for our affiliates. And the assumption, kind of was, I guess we'll wait and see what happens, but also, it's possible that maybe this just gets delayed. It doesn't get implemented early in March so that they could come out with a bulletin, give guidance on it before they actually implement it into the system. That obviously isn't what's happened. So now we just have a bunch of people who are confused, who don't have any guidance. I wanted to also specify, because this confused me a little bit. Kevin, if you could pull up the Legislative Digest and then go into the actual law for a second. Because when I read the digest, as opposed to, reading the couple of pages of actual law, most of the time this is sufficient, but I think this time it's not, because what the digest says is that it's looking to confirm possession of every firearm that they own or possess. But what the actual law says, if you scroll down into Section 2A, for all firearms, the register or record of electronic transfer shall include all of the following information. And it goes through all the stuff that's already in the DROS, but all the way down there at number 30, this is the specific language that it uses. Yes or no answer to a question that inquires whether a purchaser has, within the past 30 days, checked and confirmed possession of all firearms currently owned or possessed. And then if you want to take that a step further, we do also have what the DROS form now actually says, that it's been updated. It's very similar to the actual law. If you currently own or possess firearms, have you checked and confirmed possession of those firearms within the past 30 days? If you do not currently own or possess firearms, you must select not applicable. So what it's asking you, if you have checked or confirmed, is this the specific language you're talking about, where you're saying, there's really nothing wrong with putting no there as far as the law is concerned?
Well, so what I'm talking about there is that when you answer that question, there's nothing in the penal code or federal laws or regulations or any Cal DOJ regulations for that matter that say if a person answers no to that question, they cannot purchase the firearm. And so in a case of like a person's background check comes back and they have a felony on their record or some other prior conviction or prior contact or whatever that actually prohibits them by law from owning or possessing firearms, that would be a basis to deny someone a transaction. But in this case, simply answering the question here, regardless of the answer, there's no penal code that says if you answer no, you cannot buy the firearm. You have to go back and check and confirm possession first before you actually go and do this. And so that's kind of the confusion here is like, well, if someone, regardless of how someone answers the question, there's nothing in the law that suggests that that would cause a prohibition on someone actually purchasing a gun. So then that begs the question, what's the point of the question in the first place? Which we all, of course, without any update or information from DOJ, we just don't know.
Well, and I feel like when you don't provide any guidance and these questions are kind of left unsaid, we kind of have a basic understanding that the ultimate goal of gun control laws, it's a singular individual goal. So then you start begging the question, is this more nefarious than it looks on the surface? I think one of the paths to get there that's kind of being talked about is, does this lead to a registry by allowing law enforcement to get some sort of warrant by you claiming that you don't have possession of your firearms, which would put you into a category of having to report them lost or stolen? Do you see that as an opportunity here, especially when you're starting from the fact that there's nothing in the penal code that says a yes or no would even prohibit you from purchasing a firearm in the first place?
That is a complex question for a number of reasons. But first and foremost, I'll state this, that the laws can and have been abused by politically inclined authorities or individuals that do not fully understand the intricacies of California's firearm laws, let alone our laws in general. And so there's always a possibility that we'll get that story of, as you say, that, the one person answering no to this question, and then all of a sudden they've got a bunch of armed agents knocking on their door kind of thing. But that being said, the actual laws at issue here, in reality, we have in California this negligent storage provision requirement that basically requires you to keep your firearms locked in a manner that prevents access. And then if you were to actually have your firearm lost or stolen, you have an obligation under California law to report that loss or theft within 5 days of when you knew or reasonably should have known that your guns were actually lost or stolen. And so, as a general rule, or as a general analysis, I'll say in this regard, there's nothing about simply answering no to this question that would then suggest that you knew or reasonably should have known that your guns were lost or stolen. And so, because of that, there should not be any means or method in which a law enforcement agency or officer could use the answer to this question as the basis, for example, for like a warrant or some other, predicate to a criminal offense of some type or anything along those lines, because they're two wholly separate, distinct issues. And so there would have to be something more than just the person answered no to the question for that to happen. Now, again, going back to what I said earlier, of course, there is the possibility for abuse here, and we'll have to deal with that when we come to it. But as it stands, from a legal standpoint, I don't see a basis for an individual having anything to worry about based on how they answered this question, because on top of which, you're supposed to answer these questions truthfully under penalty of perjury. And so simply telling the truth is not in of itself something to suggest that a criminal act has taken place here. And so I don't think that that would be, again, sufficient basis for things like a warrant or other type of criminal prosecution just because you answered no to this question.
As kind of a final thought here, as an attorney who's constantly, in communication with the Department of Justice, you're constantly challenging laws in the state. What's kind of your opinion of the current state of things without the guidance from the DOJ? How do you see this moving forward? Does DOJ have to kind of come back and recoup what they should have done? Or does it just move forward without any clarification?
Well, interestingly enough, I mean, this is DOJ doing what the legislature has told them to do. And so they've added this question to the form. And so I think, and I would hope that DOJ is smart enough to also recognize that just because this question has now been added, there's still no basis for them to deny someone a transaction based off of their answer here. And so because of that, like I said, what we're doing is we're kind of just waiting to see what happens as far as what DOJ actually does with those transactions that we're watching where the person actually said no. to that question. And so then we'll have a better understanding of that. And presumably, if a person is denied because they answered no to this question, again, the issue is, well, what's the basis for the denial? And there's no penal code or statutory authority for DOJ to deny someone simply for answering no to this question. And so in that situation, if that does happen, I would say the person that actually answered no to that question would have strong basis for a lawsuit challenging the denial at that point, in which case they could potentially challenge DOJ for their decision to deny them. And so, like I said, we'll have to wait and see. But as we understand it right now, the system hasn't flatly denied the purchase or the attempted purchase in those cases. So it could very well be that the transaction will ultimately get approved, and it'll just illustrate, the meaninglessness of this question in the first place. But again, we have to wait and see.
Well, a little bit of reassurance there. Obviously, this is something that we're going to be following along with. And Matt, I've got a feeling we're going to be calling you on soon to come back and talk about some new stuff that we've learned on this. But for now, I want to thank you for coming on and sharing this insight with us. I appreciate it.
Of course. Thank you.
Absolutely. And guys, once again, if you like this kind of content, if you want to see more, if you want to make sure that others in California are seeing this content in their feed, please be sure to like, share, and subscribe to these videos. It really helps boost our signal and get this out as far and wide as possible. And as always, we want everybody to be as informed and educated as possible when it comes to the Second Amendment litigation, legislation, and the cultural efforts here. So thanks again, guys. We'll see you on the next one.